So we will be dealing with, again, the right of establishment and free movement of services today. We started with the treaty provisions, as you would remember. We will deal also in short, in brief, with the free movement of lawyers in the European Union as well, as I have promised you last week. All right. So when did we speak about freedom of establishment? Freedom of establishment. Yes? What's your name again?
Dilara.
Dilara, yes.
It was regulated between 49th article and 55th article in the Treaty on Function of the European Union. And it gives the three rights for the who use this, who exercise this power. First one is right to enter to another member state and stay in there on a long term. And second is take up and pursue establishment. And the third one is set up and manage undertakings in these member states.
Okay, so who are covered by the right of establishment? Who? Only natural persons? This is a question. And legal persons. This is important. According to the founding treaties, the natural persons may enjoy this right of establishment or companies. For the companies, I would refer you to your chapters. I'm not going to explain it in class. Please read from your chapters the right of establishment of the legal persons in the European Union. Okay? This is one important thing we will be dealing with. Second, the provision of service in the right, as regards right of establishment, is on permanent basis, right? We have spoken about that as a difference between right of establishment and yes, free movement of services. Today we will be dealing with the freedom of establishment, the right of establishment in a more detailed way, and we will be speaking about certain secondary legislation as well as regards the right of establishment. Then we will be doing the same for the free movement of services. As we have mentioned, the right of establishment is provided under Articles 49 to 55 of the Treaty on the Functioning of the European Union. Article 49 includes both the individuals and the legal persons as the ones who enjoy the right of establishment. As regards the rights conferred on individuals or natural persons, Article 49, paragraph 2 makes a distinction between the right to pursue an activity and the right to access or to take up an activity. The second one is when you start an activity and enjoy right of establishment, when you have an access to an activity in a member state, and it includes the right to work as a self-employed person, licensing requirements or qualifications. As far as the right of access to self-employment is concerned, as far as the right of access in Turkish, işe giriş koşulları, ha? İşe giriş, işe ilk giriş. As far as the right of access to self-employment is concerned, Article 49 of the Founding Treaty applies to both primary and secondary establishment. What do we mean with that? When we say an individual enjoys right of establishment, and this provision on the right of establishment covers both primary and secondary establishment. What do we mean? Yes, Kaan?
It doesn't matter if it's the main job or the...
Sorry, it does not matter?
It doesn't matter if it's a main job or a supporting one.
What do you mean?
Actually, you can be a teacher or nurse, and you can be a self-employed person at the same time in order to support your family.
No. No, we speak about right of establishment in the member states. So yes, Atakan?
Maybe if you have a primary establishment, primary main place, and then you have its branches in other places.
Exactly. So can you apply this example to the right of establishment in the EU? How could this happen?
Maybe your main place is in, let's say, Italy, and its branches are in Germany or...
Okay. You are a German citizen, okay. As a self-employed, you may start an activity in Italy as a primary establishment, all right? If you are a lawyer, for example, a German lawyer, and you may establish an office in Italy enjoying the right of establishment. This is primary establishment. But as a German lawyer, when you already have an office in Germany, you may also establish another branch or an office in Italy, for example. This is your secondary establishment. Therefore, Article 49 of the Founding Treaty includes both primary establishment, where an individual leaves his member state, for example, state A, to establish a permanent residence in state B. This is primary establishment. And also to secondary establishment when an individual maintains his establishment in state A while setting up a second professional base, such as an office or a chamber in state B. Article 49 provides for the principle of equal treatment. According to that provision, each member state is free to regulate access to a profession in its territory. Every member state, when there are no EU rules in a given profession, every member state is free to regulate the access of a profession in its territory, provided that the national regulation does not directly or indirectly discriminate on the grounds of nationality. As you would remember, we speak about directly discriminatory measures. Directly discriminatory measures in Turkish? Doğrudan ayrımcı uygulamalar. When the national provision treats migrants less favorably than nationals. When a national rule treats migrants less favorably than the nationals, we speak about directly discriminatory measures. These can only be saved, such national rules can only be saved because of the reasons of public security, public policy, and public health. The derogations are provided under Article 52 of the Treaty on the Functioning of the European Union. Derogation? Exceptions are provided under Article 52 of the Treaty on the Functioning of the European Union as public policy, public security, and public health. For example, a Belgian rule that prevents a qualified Dutch national from practicing as a lawyer in Belgium on the grounds of his nationality breaches Article 49, a national rule which prohibits the practice of nationals of other member states just because of the fact that they are nationals of other member states breaches Article 49. Yes?
Does Court of Justice explains these terms? Public security, public...
Yes, but this would take around 3-4 weeks for us to explain. That's why I told you to read the derogations from the chapters, okay? There is a huge case law about these derogations, both for goods, for workers, and for establishment and services, okay? Yes?
I wanted this case because he was lawyer, Dutch lawyer, but did you study in Belgium? I don't know the rules in Belgium, but for example in Turkey,
we will come to that.
Study law,
okay, yes.
to become a lawyer.
Yes. I will explain them in detail. Okay. This is just the beginning, okay? I will explain you the rules as regards lawyers. All right? Secondly, what is also prohibited is the indirect discriminatory measures. Can you give me an example, or how would you explain an indistinctly or indirectly discriminatory measure? Yes, Deniz?
For example, not on the ground of nationality, but on the ground of, for example, language skills. Like the rule may say you need to speak at least 2 languages, but the participant may only speak 1 language.
Yes.
English.
There is no discrimination based on nationality here. The rule itself does not make a distinction based on nationality between the migrant and the national. Therefore, the rule treats the migrant and the citizen, the national, in the same way. But, in fact, there is a disadvantage on the migrant side. Such measures also breaches Article 49. For instance, national rules which require registration for professional bodies to be able to have an access to self-employment in that member state. Or national rules requiring the persons, professionals, to hold a license before they start practicing. These rules are usually considered as indirectly discriminatory because they place a dual burden on the migrants. The migrants first have to satisfy the requirements of their home member state to practice, and then the requirements of the host member state. Although the nationals only require to satisfy the conditions of their own member state. As you will be seeing, for instance, in the free movement of lawyers, as regards the right of establishment, the lawyers are able to use their titles when they obtain it from their home member states. But for that title to be obtained, first they have to satisfy the requirements and they have to be registered for the professional bodies. And then when they get that title, then it is possible to use that title in a second member state. But for that also, if it is required that they have to also satisfy certain requirements to be able to be registered for that professional body, then there is a dual burden on the migrant. If that person does not move from one member state to another, it will be only sufficient to fulfill the requirements of one member state only. Therefore, these rules, which do not at their face make a distinction between nationals and migrants, but in fact there is a disadvantage for the migrants, are considered as making a distinction or indirect discrimination between the nationals of the member states. The second aspect of the right of establishment is the right to pursue an activity, meaning the exercise of activities as a self-employed person. When we say exercise an activity or exercise a profession, we mean the terms and conditions under which a profession is performed. As regards the exercise of the right of establishment, there is also, or the main principle here is also equal treatment, meaning that national rules which directly or indirectly discriminate on the grounds of nationality in respect of exercising a profession is also prohibited under Article 49. For instance, the Italian law, which provided that dentists who transferred their residence to another member state lost their registration with the Italian Dentist Association, the Italian dentist, the Italian law, stating that the dentists who transfer their residences to another member state also lost their registrations with the Italian Dentist Association is found to be contrary to Article 49. This rule did not apply at that time to the Italian nationals, but only to the foreigners. Therefore, it was found directly discriminatory. The principle of equal treatment also applies in respect of access to various general facilities. The principle of equal treatment also applies in respect of access to different general facilities which are necessary to pursue self-employment activity. For instance, tax advantages, social advantages, which allow only nationals to enjoy certain rights, are discriminatory. For instance, rules which only gives the right to purchase immovables to nationals only, or to lease housing to nationals only, are found discriminatory. Therefore, as regards right of establishment, there are today the provisions of the founding treaties, and there are also secondary instruments. One of the main secondary instruments is the Directive 2005/36 on the recognition of professional qualifications. The lawyers are not included here. There is another directive about lawyers, as you will be seeing. This directive applies all nationals of member states who would like to pursue an activity, to pursue a regulated profession, in a member state other than in which he obtained his professional qualification. Therefore, the directive provides rules for regulated professions. We will be seeing what it is. And for this directive also applies for persons who have obtained their profession from a member state, but who would like to exercise that activity in another member state. A regulated profession involves a professional activity which requires specific professional qualifications. for which evidence of formal qualifications or competence or professional experience is required. According to the directive, the recognition of professional qualifications by the host member state, ev sahibi devlet. Recognition of professional qualifications by the host member state allows the beneficiary. Sorry? Yararlanan. Beneficiary to gain an access in that member state to the same profession as the persons who are qualified in the host member state and under the same conditions as its nationals. Therefore, once your professional qualifications are recognized, then you are accepted in the host member state as if you have obtained your qualification in that member state, and you will be able to work in the second member state under the same conditions as its nationals. This is the basic rule provided under Article 4, Paragraph 1 of the directive. The directive then distinguishes between those providing services and those which would like to establish themselves. When I say establish themselves, I want to mean to provide. I am making a distinction now between provision of services and exactly. When I speak about people who would like to establish themselves, I am referring to the right of establishment, okay? So here we say that the directive makes a distinction between the services the ones who would like to provide services and the ones who would like to enjoy the right of establishment. As far as the free provision of services is concerned under the directive, any member state national legally established in member state A may provide services on temporary and occasional basis in state B, according to the original professional title, without having to apply for recognition of professional qualifications. Therefore, according to the directive, according to the provisions of the provision of services of the directive, the free provision of services is provided, free provision of services, and according to that, any national of a member state legally established in member state A may provide services on a temporary and occasional basis in member state B under their original professional title without
And apply, register.
For recognition.
sorry, without,
Having to apply for recognition of professional qualification.
yes, or in short, without having their professional title recognized by that member state. If the profession is not regulated in the first member state, because the directive only applies for regulated professions, if it is not regulated in the first member state, then the person concerned must provide evidence for 2 years experience. 2 years experience. But attention, this 2 years experience is only required if that profession is not regulated in the first member state. If it's regulated, then 2 years of experience is not required. Wait. Second, right of establishment or freedom of establishment. As regards freedom of establishment, which means professionals which are established in one member state other than their own member state, home member state, on stable basis. The situation of these people are also provided in the directive. And directive provides for 3 systems of recognition of qualifications for the freedom of establishment. The first is a general system of recognition of professional qualifications. The general system provided by the directive applies to all professions which are not covered by specific rules. It also applies where the migrant does not satisfy specific conditions set out for other recognition schemes. Second, the directive provides for a system of automatic recognition of qualifications attested by professional experience, meaning which require professional experience. These are listed as industrial, craft, and commercial activities in the directive. Therefore, for such qualifications to be recognized, duration and form of professional activity is taken into account. And also, professional experience is required. For such professions to be, or qualifications to be recognized, you need the professional experience, the amount of professional experience, you need duration and form of professional experience to be taken into account. And third, the third issue that is provided by the directive is the recognition, the system of automatic recognition of qualifications for specific professions. According to these rules of the directive, which are provided under Chapter 3, each member state must automatically recognize the qualifications or the certificates of training for the following professions: doctors, nurses, dental practitioners, pharmacists, midwives, midwife in Turkish, ebe, architects, veterinary surgeons. According to the directive, therefore, the member states are under an obligation to automatically recognize the training certificates of these professional groups. Lawyers are not provided or are not covered by this directive. The legal profession has been subject to different directives. The first directive on the recognition of professional qualifications of lawyers was dated 1977. It was the first directive on the legal profession, Directive 77/249. Today, there are two different directives which concern lawyers. The first one is this one, the first directive that was enacted. This provides rules for the freedom to provide services, the exercise of lawyers, or the exercise by lawyers of freedom to provide services. And second one is 98/5 on practicing law in other EU member states. According to these directives, lawyers established in one of the member states of the European Union can offer their services on a temporary basis in another member state. For them to do so, they have to keep their professional title from their home country, home member state, which is expressed in the language of their home country. They have to have their own title or professional title from their home country, which is expressed in the language of their home country. For example, the titles of barrister or solicitor, which is obtained from Ireland or the United Kingdom. They can use their professional title in other member states when they provide services on temporary basis. Second opportunity is the establishment in another member state. Again, lawyers who have established themselves in one EU country may establish themselves in another EU country and carry out the same activities in the second state on permanent basis. Okay. when lawyers, well, where are you?
Lawyers who have established themselves in an EU country.
You are already quote me. No problem. Yes, when, okay, the lawyers already established in one member state may also provide their services in the second member state on permanent basis, meaning they can also enjoy the right of establishment in another member state. To do so, again, they have to keep their home professional title. To establish themselves in another member state, they have to register with the authorities of host country and they have to provide proof of certificate of their registration for the home country. They have to register with the authorities of the host member state and they have to provide proof of their registration in their home country as well. After 3 years of regular practice in the host country, the lawyers may apply to acquire the professional title of the host country. Therefore, in the first 3 years, even if they establish themselves in the second member state, they have to use their home country title, professional title. They have to first, they have to be registered with the, as the bar, for example, of their home country, and then they have to show this as a proof for the registration of their, registration for the second member state, the host member state, and after 3 years, then they can start using the professional title of the host country, okay? But attention, of course, the directives, these directives only provide rules for the provision of services and the right of establishment of lawyers which are educated in one of the member states of the European Union. We are not subject to the same rules, okay, since we are in the status of third country nationals in the European Union, okay? But of course, we have different rights arising from Ankara Agreement, not as lawyers, but as Turkish nationals. And we will be dealing with those rights, the rights of migrants, Turkish migrants, in the second semester. All right? Let's give 10 minutes break.